Welcome back, everyone, to this KMVTech Education Explainer. Today, we're opening up page 1 of Module 6 in Evidence Law 1, the Standard of Proof. Go ahead and get your notebooks and pens ready. I'm going to be speaking a bit more slowly and deliberately today, just to make sure you have plenty of time to get down the core concepts, the definitions, and those crucial statutory references you're absolutely going to need for your exams and your future practice. Okay, let's dive into this. We've got 6 clear sections on our agenda today. We'll start with the companion question, move into defining the standard, look at the criminal standard, then the civil standard. After that, we'll explore one event, 2 outcomes, and wrap up with a summary and discussion. Section 1, the companion question, and the stakes in Ugandan courts. So, you've all successfully knocked out 5 modules of evidence law up to this point, but I want you to view this explainer not as a brand new, totally isolated topic, but as a direct continuation. It's a building block placed right on top of what you just learned. In Module 5, we spent a lot of time establishing the burden of proof. You learned who must prove what. If a party makes an assertion, well, they bear the burden of proving it. But Module 6 answers the natural and essential companion question, which is, how much proof is actually required? If Module 5 is the who, Module 6 is the how much.
This brilliantly illustrates the real-world application. Imagine 2 cases happening in Ugandan courts on the exact same day. In one scenario, a man stands accused of murder before the High Court in Kampala. The prosecution has called eyewitnesses, they've brought in a pathologist. In another scenario, down in a magistrate court, a trader is suing a supplier for failing to deliver goods worth 5 million Ugandan shillings. Take a moment to just consider those 2 vastly different stakes.
In both of those cases, the burden of proof has already been allocated. The prosecution has to prove the murder, the trader has to prove the breach of contract. But the judge and the magistrate now face the exact same question. How much evidence is enough? So the crucial point is, how convincingly must these parties prove their claims? And this brings us right to the core of our topic today. Moving to Section 2, defining the standard and the degree of persuasion. This is where we lay down the formal legal definition, so please write this down exactly. The standard of proof is the level of certainty or degree of persuasion that a court must reach before it decides that a party has discharged their burden of proof on a particular issue. I'm going to read that one more time for your notes. It is the level of certainty or degree of persuasion that a court must reach before it decides that a party has discharged their burden of proof on a particular issue. Now, Uganda, like a lot of jurisdictions, recognizes 2 main standards. We'll explore those right now. Section 3, the criminal standard, which is proof beyond reasonable doubt. This is the absolute highest standard recognized in our legal system, and it applies in all criminal proceedings in Uganda. Let's make sure we get these statutory references into your notes. This standard applies whether the matter is before a magistrate under the Magistrates Courts Act, Chapter 19, or before the High Court under the Trial on Indictments Act, Chapter 25. It also applies in the appellate courts. And here is a really vital rule to remember. This high standard applies to every single element of every offense. The prosecution can't just prove most of a crime beyond a reasonable doubt. They have to prove all of it. Now, this isn't just some procedural rule. It's a fundamental constitutional right. Please note, Article 28, Clause 3, Subclause A of the Constitution of Uganda, 1995. This article guarantees the presumption of innocence. And in Ugandan law, that presumption intrinsically implies that guilt must be proven beyond reasonable doubt. But you might be asking, why is the standard set so incredibly high? It really comes down to policy. The law demands the highest certainty here because the consequences of a wrongful criminal conviction are severe, and they are irreversible. If the court gets it wrong, a person could be wrongfully deprived of their liberty or literally even their life. The standard acts as a massive shield against that specific injustice. Let's move to Section 4, the civil standard or the balance of probabilities. Let's see how this builds a completely different framework for civil cases. The balance of probabilities applies in all civil proceedings. So when you're dealing with contract claims, like our trader example from earlier, or land disputes, tort actions, family law, and just general commercial matters, this is the standard you're going to use. It essentially means asking the court, is it more likely than not that the claimant's version of events is true? So why the lower standard? Again, we have to look at the consequences. A wrongful civil judgment usually results in financial consequences. Now, make no mistake, losing 5 million shillings or a piece of land is incredibly serious for the parties involved. But, unlike taking someone's life or locking them in a prison cell for decades, financial transfers are generally more reversible. Therefore, the law balances the scales a bit more evenly between 2 civil parties. Section 5, one event,
two outcomes, the burden paradox.
This is where we see how these two standards interact when they're applied to the exact same set of facts in the real world. What's truly fascinating is how the outcomes separate based purely on the math of persuasion. Let's consider a murder case where the prosecution has strong, but maybe not overwhelming evidence. The judge thinks the accused probably did it, but has a lingering, reasonable doubt. Well, because it's a criminal court, that remaining doubt mandates an acquittal. The accused goes free because the prosecution failed to meet the required height of the standard. However, in a civil case involving those exact same facts, perhaps a wrongful death lawsuit, the court only needs to decide if it is more likely than not that the defendant caused the death. The lower standard is reached even though the criminal standard wasn't. And this is exactly how a person can be acquitted of murder but found civilly liable for the very same death.
Finally, Section 6, Summary and Discussion, Reviewing Module 6, page 1. Let's consolidate everything you've written down today into a definitive cheat sheet for your notes. First, we have the criminal standard, beyond reasonable doubt. It's dictated by the severe and irreversible consequences to liberty or life, and it's firmly rooted in Article 28(3)(a) of the 1995 Constitution. Next, contrast that to the civil standard, balance of probabilities. It applies to civil proceedings where the consequences are financial and generally more reversible. Ultimately, the severity of the outcome dictates the height of the standard.
I want to leave you with a provocative thought for your study groups and tutorials. I'll give you a moment to write this prompt down. A man is acquitted of murder in the high court because the judge had reasonable doubt. The victim's family sues him civilly for compensation. The facts are identical. Using the two standards we just learned, explain how he can be acquitted criminally but found liable civilly. And more importantly, as future officers of the court, is this outcome just? Make sure you get that whole prompt written down. Thank you so much for engaging with this KMVTech explainer, and I really look forward to seeing how you tackle this question.